ونركز شويه. طيب الحقيقه انا داير اركز في العجاله دي حول المساله اللي هي العمليه الاستشاريه فيما يختص بالعداله الانتقاليه. وبرضه هتكلم على مساله الاختيار بالنسبه للمفوضين الكوميشنرز، باعتبار انه دي عمليه مهمه جدا، خصوصا في تجاربنا في السودان بنلقى انه في اشكالات اللي هو غير القانون. الناس ما بيهتموا بمساله البروسيس، يعني اللي هي كيف انه يحصل استشارات واسعه. بالنسبه للاستشارات الواسعه في قضايا العداله الانتقاليه بالتحديد، يجب انها تكون حقيقه مركزه على حقوق الضحايا. دي مساله اساسيه جدا. يعني حسي لو افتكر لو عملنا تغيير في القاعه دي بنلقى انه ما في تركيز، لانه هم الاشخاص الاساسيين المعني بهم مساله العداله الانتقاليه. وبالتالي في كل عمليه الانتقال من المهم في العداله الانتقاليه هي تركز على الضحايا ومجموعات الضحايا واسرهم، ودي مساله اساسيه ومهمه جدا. طيب بيظل السؤال انه فيما يختص بالمشاورات، شنو هي الخطوات اللي يفترض بالنسبه لاي قانون يتم اتخاذها؟ انا شايف انه في العمليه الان بالنسبه لمشروع العداله الانتقاليه، مشروع القانون، وايضا بالنسبه حتى لكل القوانين عندها علاقه بالمشاورات الواسعه في قضايا اساسيه ومهمه، ما قاعد يتم المشاورات الواسعه. ودي ظهرت لنا حسي في الكلام مع بعد اتفاق جوبا انه ما في الناس ما عارفه حول القضايا التي كانت تناقش، ظهرت ما بعد ما تم الاتفاق حولها. فاحنا ما دايرين في العداله الانتقاليه تكون هي نفس المنهجيه. وبالتالي النقطه الاساسيه انه لابد انها تكون هي محورها هي الضحايا ومجموعات الضحايا واسرهم. وده بيتطلب انه شنو الخطوات اللي يفترض انها هي تتم، اللي هي مساله انه لابد ان يكون في حمله واسعه في وسائل مختلفه بالنسبه للتنوير والتبصير بالعداله الانتقاليه. المساله الاخرى لابد ان يكون في عمليه المشاورات دي فيما يختص بالقانون وفيما يختص باختيار المفوضين انه يكون في زمن مربوطه بتايم فريم ورك عشان تقدر انت تشتغل مساله العداله الانتقاليه دي بشكل مهم جدا. ومساله الاطار الزمني هي مساله مهمه جدا للتحضير في مساله تحت القانون، للتحضير بالنسبه للمساله بتاعت مشاركه المجتمع المدني، مشاركه مجموعات
societal organizations and the involvement of the the victims' families and the different concerned groups, the media. All of these need to have a time frame. Also, of the criteria that should be applied, protection of everybody who is involved in transitional justice, because some people are prone or are susceptible to harm. So this relates to the principle of non-harming anyone who is involved in transitional justice, and this is something that Hind referred to earlier when she talked about the report. The report on how people view or perceive transitional justice. We find that some groups did not make their opinions, did not voice their opinions because they don't have any background about transitional justice, especially when we talk about the events of June 3rd, where we have very sensitive information, confidential information, so they don't trust, they have no confidence, and that's why, because they lack confidence, they don't voice their concerns and their opinions. So it should involve as many groups as possible. That's why we should provide protection. So protection is lacking. That's why many people are reluctant to be involved and to participate. The question number 2, who conducts the wide consultations? Is it the civil society organizations or the victim groups or the government? According to the international experiences, these consultations are the responsibility of the state.
تقوم بعملية المشاورة الوزارية. ونحن نتكلم بقى شوي حوالينه.
I'm going to shed more light about this issue from the practical point of view, and I'm going to answer the question whether the Sudanese government is competent enough to conduct the consultations, but principally from a principal point of view, the government and the state are the ones to conduct these wide consultations. So who is to be involved? Who is to participate? Who? Initially or principally, according to many experiences, this process should be a complete process and should be well representative of many sectors and should be victim centered, and also should also focus on the victim groups and the families of the victims, and also should reflect the demographies for the victims of the victims. For instance, if we want to conduct discussions, we have to first have mapping of the victims, not the civil society organizations. For instance, in Eastern Sudan, Northern Sudan, Darfur, and Blue Nile. So this mapping would show us or would constitute a baseline for the wide consultations. For the groups that need transitional justice, another point is that we should involve different groups of people, different groups of people and we should also poll those who have been victimized. I'm talking about ethnic minorities. I'm talking about youth groups, women groups that have been subjected to many violations, including sexual harassment, rape, and victims of war. This is part of this democracy, so that we can have a true picture. Another important point relating to wide consultations, we have to determine our goal or objective. What is the objective of these consultations? The main objective of these consultations is that the victimized people should have their voices heard. If their voices is not heard, that means this process is incomplete. This is a very crucial element if we want to gauge to how extent the project of the Ministry of Justice has addressed this or has answered this condition. We will find we have to see whether the victim's voice is heard or not. So consequently, we have to focus on the victims. The main objective is that the consultation in the final analysis, people should own to this process. People should, if people do not trust in the consultations and do not trust the law, and they have no confidence in the law, and they don't perceive that the law is well representative of the victims, people will not have a sense of ownership. Consequently, people will lack any confidence in the commission when the commission is created. and they will lack confidence in the law. So it is very important that we should pay attention to this aspect so that law is acceptable to everybody. Concerning the consultations, deliberations is one element which is very important. Deliberation should also be wide, in order not to exclude the victims and the opinions of the victims. There should be a record of the opinions of the victims. Earlier on, I liked what these young ladies were doing. They were taking minutes. I liked that. This is a very important thing. Sometimes we hold some meetings and sessions of deliberation on these issues, but nobody takes any minutes verbatim. A record should be in place to include everything. So the state should bear this responsibility of keeping this record. This record is very important for these groups, so that we know which issues to be addressed, and then this is to be shared with civil society and the media, so that we can go forward with all these procedures and reach a very definite result. So in this regard of consultation, has a value which is called meaningful participation. All consultations should be real and should reflect all the opinions. Even in peace making and constitution making, there should be consultation. Sometimes we have negotiations. People reach certain solutions and they reach a certain agreement, but we have to ask ourselves whether these results are meaningful or not. If we have popular consultation, these popular consultations should reflect the opinion of all the people involved, all the people. In this regard, I want to talk about three experiences: the experience of South Africa, of Kenya, and Sierra Leone, and Brazil. Let's examine how these experiences began. This is relevant to our discussion topic today. Have they started with the transitional justice, or have they started with the creation of the Transitional Justice Commission as the Ministry of Justice has proposed? So the question that arises, how these experiences went about achieving transitional justice. Do we start with the consultations first or with the commission first? I tried to find an answer to this question in the international questions to know what they exactly did. As for the Kenyan experience, they created a commission for truth and reconciliation. So they initially planned to create it in 4 weeks, but they found out that this could not be done because the timeline is very, very limited. The time is very limited, so they had to extend it for a longer period of time. Why? Because the negotiations took a long time between the government and civil society. Consequently, the draft law in the Kenyan experience, they established the law, and then on March 13th, 2009, they created the the commission. So the timeline for or for the negotiations on the draft law took a long time. Civil society led this process in Kenya, but according to a certain draft law. There existed a draft law and a committee called a multi-sectoral task force was created, which is a big umbrella under which there were many civil society organizations. So they led this process, in addition to the fact that there were involved the Ministry of Justice and the Parliament. They had a problem. Pardon. There were that had to do with pardon, and they did not know exactly who deserved the pardoning. This was a problematic issue for them, but finally the draft law was adopted and in 6 months was enacted and was passed. So they started with preparatory committees with the participation of the Parliament and the Ministry of Justice. Our problem here is represented in the lack of Parliament. As for South African experience, Truth and Consultation Commission was created. So in South Africa, the consultations took 5 years. This was a very long, protracted process, which were conducted over many rounds. It started in 1990 and ended 1995, where a law called Promotion of National Unity and Reconciliation Act was adopted. This took 5 years. In South Africa, the process was led by civil society organization. It's called Justice in Transition, JIT. They were the ones who led the process, but this process was linked to many workshops and conferences and a lot of deliberation, and it was led by this particular organization in collaboration with the Ministry of Justice, which was led by Minister Dula Umar. After this was agreed upon between civil society and the government, so we have a Justice Committee or Justice Portfolio Committee in the Parliament. They were also responsible for that process, and they conducted a lot of dialogues. So this law was finally adopted. So South Africa took 5 years, Kenya 6 months. We have Sierra Leone model as far as popular consultations or wide consultations. In Sierra Leone, the process took a shorter time, which was 7 months. However, in Sierra Leone, there was no parliament. They did not have a functioning parliament. So the process was led by the consultative conference, the general consultative conference, which were concerned with peace realization. So this was linked to the peace process, and after that, on the 22nd of February 2000, a commission, Truth Commission, was created, and this was linked to peacemaking. Ironically, in Sudan, the peace process in Sudan and the transitional justice although they are interlinked, or they but here in Sudan we don't relate them to each other. We have a workshop just a while ago about peace, transitional justice, which was organized by a peace council. That means we don't have a vision, a sound vision on how to relate to this, to the two processes together. So if we check the constitution or the chart, we find that there are some provisions about transitional justice and about peace. So the question that arises, to what extent we can combine all the elements, relevant elements, in one project, so we can have harmony. Juba Peace Agreement also contains some elements concerning transitional justice and peace. So there are some technical issues that we have to consider and to take into account. There may be a potential agreement with the other movements that have not signed yet, the non-signatory. So we have to take care of this. So one of the mistakes of the Constitutional Charter, Chapter 12, there was some problem with Chapter 12. It should have been very detailed. It should have expressed the opinion of the forces of freedom and change on transitional justice and the details or nitty-gritty of transitional justice, how it's conducted and who conducts it. But at that time, this vision was lacking. So there should have been some details about that. This could have facilitated our process and work right now. So there was no vision. The vision was lacking, and this has given rise to the current problem that we are living right now and we are facing now. So we have so this indicates that there were no guidelines in the Constitutional Charter. It lacked the standards of creating such commission. The final model or experience is the Brazilian model, which took 3 years, and civil society led the process, and they demanded the creation of Truth Commission. A national conference of human rights in 2008 was held there. Afterwards, in 2011, the Truth Commission was created, but in the beginning, the consultations were conducted under the supervision of many working groups. These belong to civil society and also to the government. This eventually led to the creation or to the adoption of the law. Another issue relates to the appointment of the commissioners. This is a very important issue. According to the current draft law, two conditions have been cited, which is integrity. But usually this does not resolve many issues. Usually we have neutral and people who are honest, but usually maybe they are not competent. We have had many commissions where these commissions were not able to perform or to function very well. Let me give you an example of the Human Rights Commission. The law which has created this commission was very good, but when the commissioners were chosen to lead the work, there was a problem in choosing the competent commissioners, because the laws do not delineate the process of choosing the commissioners. So there should be conditions for the appointment of commissioners, but the conditions of appointment is different from the process of appointment itself. So, for instance, if I want to choose 5 of you as commissioners in the Transitional Justice Commission, most of you will be honest people, good people, and independent people. Usually, independence is very important because the constitutional charter gives the power of appointment to the cabinet as a procedure, but they don't. The cabinet does not have to choose particular people, except through certain procedures. And I hope that the law should address this issue and also delineate the procedures of the appointment of the commissioners. And we have seen this in the appointment of many ministers. It became very clear and very evident that we don't have a process for appointment, so the criteria for appointment are very important and crucial, and they should be incorporated in the law. In many countries, the appointment is done through the parliament, is done through the public hearings, etc. So it is very important that the law stipulates the process or stipulates the appointment process. Thank you very much.
Thank you, Dr. Mohammed Babikir. I will present His Excellency Khalafallah from Khatim Adlan Center. You have the floor, sir. In fact, I'm coming from two bodies, Al Khatim Adlan Center and the Civic Alliance for Transitional Justice. And there are some members of this alliance present here in this workshop. Dr. Muhammad covered a lot of the points. We would like to thank Sarah International for the study that has been conducted, and they had some participants who came from different states. In some workshops, people focus on those who are coming from Khartoum state, but having representatives from the different states is something good, because Khartoum did not represent the Sudan. So it's high time to go to the states or to bring people from the states to participate in such workshops. In Al Khatim Adlan Center, or the Civil Alliance for Transitional Justice, we think that it should be included clearly in the constitutional charter, that in fact gives a good affirmative to the transitional justice. This is the first time we had such a document that refers to the transitional justice, plus the fact that Sudan is today having a new phase, because for the time being We are the country where the president has been accused for crimes against humanity, and at the same time, Sudan is maybe the only country in the world where the case has been referred to the ICC by a resolution of the Security Council. This is maybe a precedent in the history of the United Nations organization. So a country member of the United Nations who is refers to the ICC. That's why I think in the process of the transitional justice, people are looking at us and they're waiting to see what we are going to do after this revolution. That's why we need to present a model, a Sudanese model, that can treat the main issues concerning the victims whose rights has been violated. This model may be a little bit different, and the means and the procedures may be different, but the main goal is the same. When we had a strategy for transitional justice, we addressed the government. We assisted in the virtual meetings, not because the government is not serious about the case, but we were keen to be part of this model that can respond to the different conflicts and the violations that took place. And we presented, in fact, a strategy for the meetings and the consultations, where we adopted a number of mechanisms, principles that can guide the transitional justice. And this document has been submitted to the government, but we didn't see this document in the different procedures. So we have the same objective, the same target, but the means and the procedures can be concerted. Dr. Abdul Salam was talking about the importance of the establishment of the commission or the law. In the alliance, we thought that we should start by a committee, a national committee, that can deal with the transitional justice. This committee can propose a draft law. It can also nominate a number of people from whom we can choose commissioners, because the commission is a administrative body, and it can also organize the conference, the national conference, and the recommendations of the conference, the outcomes should in fact be the basis for the law and the nomination of the commission. We're going to have a problem concerning the body that will nominate the commissioners. We know that the cabinet will decide, but who is going to nominate? Personally, are we going to follow the same methodology for the high positions? I won't say that we are not agreed, but let us sit together and reach a compromise at least, and to have good resolutions that can help anyone. Another point that I would like to focus on and Dr. Abdul Salam talked about concerning the law. Some comments concerning the establishment of the Commission, Article 4 concerning the formation of the Commission. We're talking about the period 3 years that can be extended, and I'm afraid that we will understand from this article that the transitional justice should be established. This is the time frame for the transitional justice, just 3 years of time, or to be linked to the transitional period. We should know that the transitional justice is an ongoing process that should not be related to a certain frame of time. We may talk about maybe 15 or 20 years. It depends on the trials. So when there is nobody whose the rights had been violated, we can say that the mission has been accomplished. Otherwise, it should continue. So why determine 3 years? Why not choose more time? So I think 3 years link the issue with the transitional government. In the national program for transitional justice, that should be built on the outcomes of the National Conference for Justice. That is D, the same article, Article 10, D. I think the formulation of the program is not appropriate. Because the Commission is just there to supervise and to concert efforts. So for me, the formulation of the national program is not clear for me. And I wonder, in fact, if the international conference is going to decide the program for the transitional justice, we need to be more clear about this point, because after the national conference, the recommendations should be submitted to the cabinet. It should be ratified, and it becomes a law. In fact, the term in Arabic is not a good one for me. These are, in fact, the terms that were used by the former regime, and I think there are other words that can be used rather than mukhrajat. So let us choose another word, another term for that in Arabic.
It doesn't sound nice.
For me, the term doesn't sound nice. Concerning the functions and concerning the mandate of the chairperson who follows the resolutions of the Commission. And I think this is not the function of the President. There is a Secretariat General, and this Secretariat has got a number of technical departments. So he can, in fact, appoint a department that can be responsible of following up the execution of the program. So that cannot be, in fact, the function of the President. This is the task of the Secretary General, who is accountable before the chairman of the Commission. Can remove this part to Article 13 concerning the formation of the Secretariat General, and should be one of the functions of the Secretary General
برضو قال
for the Commission.
حته معينه الماده جيم طالب جميع الاجهزه الحكوميه وغير الحكوميه
We're talking about the institutions to afford information for the Transitional Justice Commission.
ممكن يقول انا اطالب ويقول
I may request informations, but they don't respond. And I think this is a little bit weak. We should use a term that is more abiding.
يعني بعكس الفقر اللي بعد طوالي طاء النفاذ
So,
طوالي النفاذ الى الارشيف العمومي
so we had access to the archive of the state.
عن كل تشريع يمنع ذلك حتى لو في حاجه بيقول ما تنفذ
Even if there is,
طلع على
we should have access to this national archive.
فمطالبه جميع
So requesting the institutions is a little bit weak. We can use another term that is more appropriate in order to give the right to the Commission to get these informations.
بغض النظر عن كل شيء يكون في شرط اخر الجزائر
So we should have some conditions in getting these informations.
النقاط
These are the points that I would like to comment. Thank you.
بس لو في أي أسئلة لدكتور محمد.
We open the floor for any comments, questions for Dr. Abdul Salam, who presented the paper.
Yeah, sure. Okay.
Thank you. I have a comment concerning the presentation of Dr. Muhammad Abdul Salam. He talked about a point that I think is crucial, the mechanism of the nomination of the members of the Commission. Yesterday, we had a meeting with the Undersecretary of Justice concerning the draft law, and I think this is a point that we need to think about. What is the appropriate mechanism that we can use? We didn't have one, but this is a point that should be addressed. We know that the Prime Minister has got the right to nominate, but I think if there has been some candidates, we need to have a mechanism that can submit the candidates for the Prime Minister. That can help a lot in order to help the independence and the so this is an important point. Another point, which is a general issue concerning the models from different countries. I think the role of the civil society is very important. We have seen that in the models of South Africa, Sierra Leone. At first, there was no body who was, in fact, preparing. But I think today we have, from the very beginning, we have the mandate of establishing a commission for transitional justice, and we need to build on that. And afterwards, we can agree on how to establish this commission. I don't think it is important to convince or persuade everybody around the law. Unfortunately, and despite the different experiences of transitional justice and the special courts in Rwanda and Sierra Leone, there is no satisfying model that we can say that this is the model that achieve the aspirations of the people being in South Africa. So we should take that into consideration. There is no in Sudan, we are also going to try to do something and to reach a good model. Thank you. Thank you. Abbas Yunus Abdullah. Hello, yeah. Dr. Abdul Salam discussed the core of the issue, and I think we are not here just to ask questions. We are here to add and to comment on what has been presented. I would like to thank the efforts for this draft law. Abdul Salam talked about the experiences of a number of countries, South Africa, Sierra Leone, Brazil, and Kenya. As for South Africa, there had been a consultation between ANC and they who participated since the 90s. In fact, that helped a lot to be on the track, because the transitional justice law became part of the constitution. Despite these four models, Dr. Abdul Salam didn't explain what of these four experiences we can get a lot concerning the nomination of the commissions. He talked about these experiences, but I think, do you think that there has been a nomination for a commissioners before establishing the law of the transitional justice? This is my question. In Sierra Leone, people started with courts. Afterwards, they had a commission. Another point concerning the victims and their participation, their voice is very important. Do you think that we just need to listen to them, or they will be part of the establishment of the commission in all its steps? This is also another point. In a transitional justice commission, the victims should be part of all the phases and the procedures. In fact, as Sudanese, we are talking about the establishment of a commission for transitional justice. So what are we going to add as a Sudanese tradition that can be of a good so South Africa so we can use customary justice systems. So why not inspire our traditions? Since the independence, we are living in conflicts. There had been a number of agreements that has been signed. There has been the cessation of South Sudan. We had got a number of uprisings, popular uprisings. So I think the legal experts should present our own heritage. What can we add from the Sudanese experience? I think that should be part of the being from which part of the country. We can have some experiences that can help in the transitional justice. We agreed on the independence of the commissioners, but how can we find someone independent? Because we have got a number of political parties who try always to be part of these commissions. So someone who is coming from the rural areas. So we have got a number of committees whose the members are not independent. In Juba, there was a real orientation. They were talking about our experiences since the independence. There are some accusations in El Salvador. People benefited from the international experience. Do we have this trend in order to profit from the international experts, in order to help us in establishing this commission? So these are some proposals that we can include, in fact, in this draft law. Thank you. Thank you, Saadi Boutros. My question goes to Dr. Mohammed Abdul Salam. I'm asking about the protection for the people who are participating in the transitional justice, being from the committees or from the victims. How can I say the truth without being threatened in my family or myself? And another question, how should you get the perpetrators who are not inside the country? Good afternoon. Leila Ali Al-Haj, a lawyer, an activist. My question goes to Dr. Mohammed Abdul Salam, who focused on the victims and the families of the victims and the procedures necessary. So I ask, I wonder if the victims have got a good concept concerning the transitional justice. And don't you think that we need to educate victims in order to participate actively in this process? Another question. We have got a number of data talking about transitional justice. Who is responsible to get all these informations in one body in the absence of a parliament? Thank you, Dr. Abdul Salam, for the presentation. I think the protection of the witness and the victims is very important, because for the time being there is no trust, no confidence in the institutions, and we have got an experience concerning the victims of some people are talking about the protection. For the time being, there is no law that protects the victims or the witnesses. So I think we need to start with an article, a clear article that should help the victims and the I think when we have a survey, we need to have interviews. There are violations. The image is not clear for the victims. So we need to have a direct contact. We need to have hearing sessions in order to reach the information necessary.
انتصار التهم, a lawyer from Zalinjay, Central Darfur State. My question is addressed to Dr. Muhammad Abdul Salam concerning the appointment of the commissioners. It is essential that women should be appointed in this commission and in the preparation committees and the legal institutional reform. Is there a percentage for women, a quota? If there is no quota, I want to know whether you have some percentage for women. Okay, and second round of questions. Let me start with Dr. Abdul Salam Sid Ahmed's question on, I think we are agreed about the criteria of appointment. This is a very important point. There should be a mechanism for choosing and appointing the commissioners. This is very important, especially in the Sudanese experience. We usually have many commissions where we have good, solid texts, but upon the appointment of commissioners, we are usually faced with some problems. Usually, these commissioners lack the competence to perform their job because they have not been appointed according to certain criteria. So the mechanism of the appointment of commissioners should be taken into account. Also, we have to ensure their independence. The fact that the constitutional charter provided for the cabinet or the prime minister is the one to appoint the commissioners. He is the one to create the commissioner, but he is not the one to draft the law. The law is drafted by the parliament. So if the parliament is going to be created very soon, then we'll leave it to the parliament. So in this case, the law should provide for the mechanism of the appointment of the commissioners. But the prime minister does not appoint. He has the power to recommend but not to appoint. So it is very important that we agree on the criteria. We have many commissions that have been created, but they are not up to the job, and they could not effect the essential changes that were required. We are going to have many commissions in the near future. We have the Constitution Creation Commission. People usually discuss the Constitutional Conference. They talk about the Commission, but they don't talk about the mechanism. We should have members who are quite independent. we have many parties to the constitutional charter. We have the Sovereign Council, the Forces of Freedom and Change, and the Revolutionary Front. So this is applicable to other commissions such as the Election Commission. It is a process which cut across the border, run across the border, especially as pertains to transitional justice. Transitional justice is crucial and important because the commissioners who are appointed are the ones to handle very sensitive issues. For instance, pardoning is an issue. Who has the authority? Is it the authority of the commission or the state? Is it the power of the state or the commission? So the commission has the power to pardon. It's not the state. So that means we have taken some powers of the state, which could be biased sometimes, to the commission, which is neutral. So usually the commissioners deal with sensitive issues such as, for example, equal justice or retribution and pardoning. All of these are sensitive issues. We have to determine who has these powers and when pardoning happens and when retribution occurs, or for instance revealing the truth vis-a-vis pardoning. All of these are very important qualities which when we take into account when we choose and appoint the commissioners, we should take them into consideration so that we can safeguard the work of the commission. What Abbas stated, Abbas talked about the international experiences, the experience of South Africa. The ANC and the other relevant parties conducted consultations, and so they had a historic settlement. Here in Sudan, we have not had this historic settlement. That's why transitional justice is a historic agreement before it becomes a legal framework. So if the state doesn't have the political will, that's going to be a problem. Especially when we have members of the government who could be involved in the violations, people who are members of the government or members of the armed movement. So it is an essential process. Transitional justice is very important and depends on the political will. In South Africa, they had the political will despite the faults, but in the final analysis, it was based on a historic agreement. But here, we have not had this historic agreement, and this agreement or this consensus has been postponed. So transitional justice is of a political nature, as has happened in South Africa. Also, the experience of Morocco, which you cited, it's about pardoning, exchange of revealing the truth. This was a result of an agreement between the factions, between the different factions, and this leads me to whether we have a model for transitional justice in Sudan. We still lack a model for transitional justice in Sudan. We need to think about it seriously. Are we going to have this formula of pardoning, conditional pardoning, or retribution, or truth and consultation? We have to think about this very seriously and choose one model so that we are able to transition from this this horrible heritage, I would say, and you can transition forward. And this is what I call a historic agreement. What happened in Juba is not a historic agreement. It's just power sharing and wealth sharing. So if we want to truly effect the transitional justice, we have to be very serious about it. Right now, there is a chance for the Ministry of Justice, for the transition government to lead transitional justice in a proper way. That we need to be involved practically. It's not just about slogans. In order to have this model, we have to consult. That's why I focus on the wide consultations. Also, we have to give voice to the victims. The victims should be involved in the process. They are the ones to determine the direction of transitional justice, whether they want retribution, they want pardon, and if they want pardon, on what conditions, and if they want reparations, what are the conditions of these reparations. This needs of us to exert a lot of effort. For example, the aspirations of the families of the victims are different from those in Nuba Mountain, are different in those of those in Nuba Mountains, are different from those who call for retribution. Some people don't want retribution, they want peace, but some other people want retribution. So we have different aspirations and different objectives. So the model of transitional justice should answer and meet all of these aspirations. That's why it should be a victim-centered approach. We can have a model. It does not necessarily have to be one model. We could have an Islamic model, for instance, which is about pardoning or retribution. It is the right of the victim's family to pardon. It is not the right of the state. It is the right of the victim's family. It is a very special right, individual right. So it is the victim's family that could pardon. So I am of the opinion that the law, before agreeing on a model of transitional justice, could pose a problem. We have concerns in this way. When we have a draft law or a law without having a model, this could lead to consultations, but we might end up unable to start the process itself. That's why we should have reconsultations, which is centered on or focuses on the rights of victims. As you have said, we still have victims for 30 years who cannot have recourse to the judicial system, let alone the families of the victims of the 3rd of June 2019. That's why there should be in place some mechanisms that will help us to achieve the objectives of this model. That's why this model needs to be widely discussed with wide consultation. That's why the formation or the creation of this commission and the appointment of some people who might render the process ineffective. This could be a problem, but maybe we can have a compromise. I don't think this is a problem.
لجنة تحضيرية
We could form a preparatory commission for the creation of this commission, or we can have a timeline
يعني إلى منطقة وسطى
where we have a middle ground and we have one objective, which is
الالتغاء الحقيقي
the real transition.
الدائرة الشريرة.
So we do away with this vicious cycle once and for all. Up until last week, we had some cases of revolutionaries being killed, and usually some investigation commissions and committees are formed without reaching any end or tangible results. So
هذا الشاب اليافع يستطيع أن يحدد من أين أتت الطلقة.
any investigator would be able to determine the perpetrator if they are serious. So we have to address these things and these issues in a very brave way.
نستطيع إنه
We
المجتمع المدني بوجود
we could involve civil society. I think there is a will on the part of the government, and we have some people who are able to try and to reach a very genuine model of transitional justice. Without this, we would not be able to achieve anything and would not be able to go forward. Saadia's question about the protection and how would we go about providing protection without any problems.
وما هي الآلية؟
What is the mechanism of providing this protection?
لازم يكون مثلا تحقيقات 3 يونيو.
I think
ما طلع لكن
the investigations on the events of the 3rd of June has not been out yet,
من
but
المسائل المهمة جدا.
it is very important and a very important element of transitional justice is a law to protect the victims and to protect the witnesses.
المنشور اللي طلعته رئيس القضاء ده ما عنده قيمة.
As for
قاعة المحكمة.
the circular that has been issued by the Minister of Justice is worthless because he talked about protecting the witnesses inside the courtroom. This is meaningless. So it is very important that we should have in place a solid system to protect the witnesses and the victims in all of the incidents that have happened. So this is the model that I'm talking about, and this also should be present in other. It should also be present in special courts.
ودي برضه عاوزة سيستم بتاع حماية.
This also needs a protection system. So, after the formation of the court, there should be procedures to protect the witnesses and the victims. This needs to be designed in a legal way so that we are able to do that. So people are reassured to go to the court. Investigators themselves should be protected and should conduct their investigations freely, and the judges should be well trained for such kinds of cases. All of this is part of transitional justice. Also, the transitional justice model could also answer the question whether we are going to hand over, extradite Bashir or not. The Darfuri people said, no, we have to hand him over. But who gave them this right to do that? Maybe the victims want to see al-Bashir, for example, being tried in Sudan. This could be a Sudanese model. You could invite the International Criminal Court to attend these trials here. And also maybe the procedures could be done here. So all of these are issues in which we could or should take the opinions of the victims and the family victims. So if there are no procedures for trying al-Bashir here, he could be sent over to International Criminal Court, ICC.
السؤال ليلى الحاج حول انه
A question about from Leila, Miss
هل
Leila,
الضحايا فاهمين العداله
about whether the victims understand transitional justice. This is a very important question. Do they understand transitional justice? I think this has featured in the survey. Many people do not understand transitional justice. Is it about reparations? Is it some people think is creating job opportunities?
وبالتالي دي برضه عندها علاقه بانه قد يكون برضه من دور المفوضيه مساله
Maybe one of the
المدني بالنسبه للناس
roles of the commission is to educate people legally about transitional justice. It is very important so that people are involved and could participate effectively.
من المسؤول في غياب
Who is responsible when there is no parliament?
هي سلطه الامر الواقع
This is the de facto authority. What is the de facto authority?
اللي هي سلطه الامر الواقع اللي هي مجلس الوزراء
Which is the cabinet and the sovereignty council. They are the ones who are responsible for transitional justice in the absence of parliament. As for the parliament, this is something, this is a different issue that will take a long time to discuss.
هل هناك نسبه محدده للنساء؟
Is there a percentage for women, a quota for percentage? According to the constitutional charter, it should be 40%, but practically we have 10% of participation. 10% women participation. Thank you.
إذا في سؤال ثاني في شداد كان داير يتكلم بعد ذاك لكن الشداد عندك 30 ثانية بس.
You have 30 seconds. Thank you. You answered many questions that I had in mind. However, the point about al-Bashir being tried here in Darfur, this is impractical. It could not happen. It could not happen. Did I say I am against the capital punishment? I did not say I want to see him hanged in Darfur. You said it. You said I want to see, many people want to see him hanged, but that's not the point. According to the current situation, this is not attainable, could not happen. Because we still have not effected judicial reform and many things have not been executed. I just examined the transitional justice experiences. Genocide, you have not included genocide. I'm talking about Human Rights Commission. At that time when it was created, I was a part of the civil society organization secretariat, and we filed a complaint against Omar al-Bashir because after that we dealt the laws and we suggested a law for this commission, and then we amended the law that the government enacted. But for appointment we had two problems. There was no support. UNDP is the only agency that supported it financially. They had vehicles, they paid the salaries of the people, and then after that they had run-ins or problems with the security apparatus. If we have a commission this important, if we don't have full support, financial support and independence, I don't think it will be functioning. It will not function well. It will just be a body, a worthless body, just like any other body. Thank you. Thank you very much. Good afternoon. My name is Hassan Ashia. Secretary General of Civil Society Organizations and member of Transitional Justice Alliance. The only solution for as far as I'm concerned is the continuity of these consultations. Many people talked about the fact that the government is not consulting people, but as considering the real situation right now of the transitional government, it is a kind of ambiguous, and there's no sustainability, and there's no trust between us and the government, and there's no transparency. As far as the peace is concerned, we have a peace commission, but we still didn't know how this peace process went. For example, the normalization in Israel, we don't know exactly what took place. There's no transparency. Whatever is said by the government is usually executed. Transitional justice is more sensitive than these other issues because of many considerations, such as protection of witnesses and the lack of law in this regard, which gives rise to a lot of sensitivity. As for the drafting a law, anything that is open for discussion will not have any problem as long as people are discussing freely and they contribute with their opinions, because we have a draft law. People could have a perception. We have consultations about the perception of transitional justice. So many people could discuss and could have a draft. My recommendations is that we continue with the consultations with the victims and the people in the conflict area. We should pose questions, clear-cut questions to these people about the law and also about the problems of the law and how we should form the committees and the reparations. And the form of the reparations, they should have a say in that. We should listen to them, and also the victims of the 28th September 1990, and all of these victims that were whose rights were violated, and their families should have a say. This will strengthen the model that we are seeking. So this will improve it, and this involves the government, civil society, and the victims. Maybe some groups are underrepresented, but maybe in the future they will be well represented. But the continuation of the consultations will give us a clear picture, and eventually will reach a law which is acceptable to all the parties. And then after that, we will have the parliament, and we will have certain political stability. As for now, things are not clear to me. But after the formation of the parliament, things will be clear, and then the commissions will be created. Things will be clear. Thank you. Muhammad Orwa, good afternoon. I have an observation and a question. As I have seen, there has not been any mention of the security sector reform as relates to transitional justice and as relates to institutional reform. Has this been overlooked by mistake, or does the Commission have a certain opinion about the security sector? Also, the political will and the dynamics. So,
Asma?
I would like to have an answer about why the security sector has not been tackled. Thank you for the opportunity. Asma Mahmoud Muhammad Taha, Cultural Center and a member of the Transitional Justice Alliance. I think the draft law on transitional justice is very different from the other laws, existing laws. So if for us to have this law effective in our social life and to it should be enacted and should be approved by the parliament. It is not enough that we enact it and approve it in the absence of a parliament. So very clearly the revolutionaries and the families of the victims, especially in the break of the sit-in, many people have a lot of reservations on the Sovereign Council. So we cannot leave it up to the Sovereign Council and the Council of Ministers to adopt this law, and then we have and the Sudanese people trust it, because there are many accusations, if not to certain individuals, but people think they have the perception that this massacre occurred under the authority of the Sovereign Council. So we should wait for the Parliament. Such a law should be an object of consensus. We need for the people to create this law so that they own up to this law. So if it is not adopted by the Legislative Council, it will not have any effect in reality. Also the 3 years or any time frame, we still, I think since 1956 there have been grievances that should be addressed, should not be excluded. Since there is a commission in this way, it should be given full opportunity. It should be a permanent one and should address all the issues, and so that people could feel that there is justice, because in addition to the 30 years of the grievances that happened, there were many violations of human rights that occurred before that. For instance, so during Nimeri regime, there were what we call summary justice, which led to the execution of many people extrajudicially. So this was not justified. So we still have victims of those extrajudicial executions. So we need a country where we have legal institutions. I think we should go beyond or go back in history before even the 30 years. Anybody who has a grievance the grievance should be addressed, and we should establish justice. This is a basic thing. I've noticed that there are many elements that are not clear. For example, gender issues. Women have been victims of many violations. These are issues that have affected living people, and many people have been wronged, and many people have been stigmatized. I think we should address these issues and also other issues such as land issues, so that the law should address these things. Also, the fact that the Commission is the one to organize the Constitutional Conference. I don't think if the Commission has its decisions approved by the Cabinet, it will lose any kind of independence. So Also, there is a lack of mechanisms to conduct the investigations. I think this law should be subject to wide consultations to people and should also be adopted by the Legislative Council and should be subjected to more dialogue so people could feel that they own to it and people could trust that there is going to be justice and going to be democracy and justice.